Ms. Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen to me. Everything you have there is overruled. And here's one of the reasons why is because you have a lawyer and your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful.
Internet, buckle up, because today we're looking at two separate sovereign citizen cases, and both of them prove just how fast courtroom fantasy collapses when it meets real procedure. In the first case, a defendant refuses to acknowledge her own name, instead claiming she's the principal, the beneficiary, and even the card holder of her own supposed estate. Every simple question turns into a pseudo-legal spell. Her public defender raises concerns about competency, and she fires back with a so-called cease and assist notice, like that means something in a criminal courtroom. Then in the second case, the judge tries again to do the basics, confirm identity, explain legal options, and once again runs straight into the sovereign playbook. Foreign agents, conflicts of interest, imaginary trusts, and demands for a verified claim against her estate. The judge calmly explains the only real choices available: keep the court-appointed lawyer, hire one, or represent yourself. Both cases follow different paths, but they end the same way: a judge who's done entertaining internet law and ready to shut it down. Stick around because both outcomes are a masterclass in how sovereign citizen tactics fail in real court.
Court calls case People versus Jade Latham.
Difficulties on behalf of the people.
Water Assistant Public Defender on behalf of Ms. Lathan. Ma'am, would you state your name for the record, please?
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, cardholder and principal of Jade Lathan.
Your Honor, I did attempt to...
Mr. Overwater, while she's given that, is this the person that you know to be the individual named in the complaint? If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of two ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man, and I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and cardholder of Jade, Ruth, and Lathan, and beneficiary.
Very well. Mr. Overwater, you are on this case, so what do you wish?
Judge,
People, here's where everything lands. After several minutes of sovereign rambling about statements of fact, settling motions, and being the card holder, the judge makes the only logical move. He orders a full competency evaluation. And this is important. The court isn't punishing her. It's protecting her legal rights. Sovereign tactics almost always backfire because they make defendants appear confused, disconnected from the legal process, or unable to understand basic proceedings. When someone refuses to acknowledge their own name, rejects their attorney, and replaces legal arguments with UCC fantasies, the court has no choice but to question mental fitness. The judge stays calm, resets the hearing for June, and keeps bond in place while the public defender prepares the order. This is the part sovereign citizens never understand. Courts deal in statutes, evidence, and procedure, not imaginary contract roles or principal-beneficiary word games.
I believe that at this point, the issue of competency needs to be raised. So I would ask for a competency evaluation. This matter be set over for a competency hearing.
I'm not
pursuant
asking
to the
for
statute.
anything, and that's coming from the horse's mouth.
I'll need an order.
I did turn in my statement of fact so that there's more than the police record on the record. I have not harmed anyone, and the cameras will reflect that. if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well, I want to settle because I'm the card holder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay. I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for
June 6th.
June 6, 2024, 9 a.m.
2020.
At this time, bond will continue. Mr. Overwater, prepare the order, please.
I will do that, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Welcome.
Good morning. Are you Janetta Pugh?
I am the beneficiary of that estate.
You're the what?
I am the beneficiary of that estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand.
Beneficiary of that estate.
Okay. What's the announcement?
Judge, it's my understanding that Ms. Pugh and her family has retained an attorney on this matter. You may, I don't know if you remember, Judge, this is when I was originally appointed on, and we were on the trial docket. She hired a new attorney at that point. Mr. Norwood, who was on the case for a while, and then withdrew. And once recently, when the case came back to me, I visited her and was told that they did retain another attorney. I was given the name of Christopher Wiley this morning, but I have not heard from him. And my understanding is that at this point still hasn't filed anything with the court.
Okay.
But I've been told that that's who's supposed to be taking over the case.
Okay.
For the record, I recognize Ms. Pugh. She's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pugh's behalf.
All right. So, Ms. Pugh, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself, or are you going to let Mr. Lewis represent you, or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it, and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus, and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel to effective defense.
It's overruled.
Okay.
You're running out, aren't you?
No, it's fine.
So here's the thing, Ms. Pugh. I appreciate your position, but listen,
Respectfully, Your Honor,
Ms. Pugh, don't speak over me.
Respectfully, Your Honor, for my incarceration.
Ms. Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen to me. Everything you have there is overruled. And here's one of the reasons why is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
I do not agree or comply to your appointed
Go back.
agents.
You already said that, and that's overruled.
Is to the state.
Go back with the bailiff. Get your own attorney or represent yourself if you don't like it.
People, looking at both of these cases together, the pattern couldn't be clearer. Different defendants, same script, refusing to acknowledge identity, rejecting counsel, and replacing real law with made-up roles like beneficiary, principal, and cardholder. In the first case, the court hits pause with a competency evaluation not as punishment, but as protection, because when someone won't engage with basic procedure, the judge is legally required to make sure they understand what's happening. In the second case, the judge repeatedly lays out the lawful options and makes it clear that imaginary trusts and verified claims don't block criminal charges. In neither courtroom does the sovereign playbook work. There is no trust shielding a person from prosecution, no magic filing that overrides an indictment, and no language that turns a judge into a foreign agent. Courts operate on statutes, evidence, and procedure, not internet mythology. And that's the real takeaway from today's video. Sovereign citizen tactics don't free anyone. They delay proceedings, complicate cases, and eventually force the court to step in and reset the process. If you enjoyed this breakdown of both cases, make sure to like, drop a comment, and subscribe for more courtroom chaos. And hit that bell, because the next sovereign meltdown is always right around the corner.